just over the amendment and the clause regarding that the attorney, so I think most everybody's represented by the JAG anyway in these cases, but there's a case for outside attorneys. And I do know in larger areas, California and parts of Texas too, where there's big bases, there are attorneys that are private that specialize in this. But anyway, so the language was, I think from the Senate is you had to be licensed in the highest court in any state, the union or something. Oh, that helps you read it. Thank you, Senator. and everybody said thought it should be like every other type of practice in Wyoming, licensed in the highest court in the state of Wyoming. And we just minute to talk about and find out what's going on. Representative Oakley's done a little poking around. I understand Senator Allison was your amendment. So as far as I'm concerned, I'm just here to listen and we get this cleaned up hopefully pretty quickly.
So let's, Representative, if you are willing to hang on just a moment, why don't we give Senator Ellis an opportunity to explain the amendment that took place on the Senate side, and then that can get us started. We'll see where we go from there. Okay.
Thank you, Mr. Chairman.
Senator Ellis, thanks for joining us.
Thank you. Mr. Chairman, I brought this amendment in response to a constituent that lives in my district. She has been involved in a multi-year sexual harassment case with the military department. And when she first saw this legislation, she was really concerned that somehow this would interfere with, similar cases going forward into the future. So I attended the Senate Transportation Committee meeting where they worked this bill, spent some time, and Senator Landon knows I stayed for the duration of the hearing. And I didn't see all of the concerns she had on cleaning up the language, making sure that we're updating necessary parts of the statute. But there was one thing that, as we talked about it, my constituent and I, that they were expressing some concern about is the ability to get outside counsel. In instances like Wyoming, because of our small population, there might be circumstances where we need to look outside the state. And so I brought an amendment initially to say that outside counsel could be, or someone could be brought in from out of state if they do a motion with or pro hoc vice. The good chairman of our appropriations committee didn't like that language. So anyway, I looked at the South Dakota because I think they have the similar kind of issue that we do, just having a small population base. And so I'm happy to provide you a copy of what their statute looked like, but we're not too far off. I mean, if you look at what's retained, one of the elements is a military judge advocate. In the initial bill, it says you licensed to practice law in Wyoming. And that's the concern, is somehow that could be narrowly construed to mean you're a Wyoming licensed barred attorney versus someone who comes in pro hoc vice or otherwise with local counsel. And so we just wanted to afford a clear understanding that they can appoint someone who is a good member in good standing in any state in the United States. I think we borrowed some language from South Dakota, or admitted to practice in any federal court of the United States. And so that was language I'd worked on with Senator Perkins at length. And so, certainly if you want to fine tune it, he and Senator Nethercott, I'll just be blunt. I know we're not supposed to use proper names, but they didn't like the pro hoc vice mention at all. And so that's the solution I'm looking for, is just clarity that we can look outside Wyoming borders for people who actually have expertise in working these kind of cases. So that's it. And I'm happy to hand anyone who wants it. I just made one copy of South Dakota's if you want to see where we got the idea. Thank you, Mr. Chairman.
Okay, committee, Mr. Chairman. Senator, thank you, by the way.
You have the digest. So this is what we've got. This is a corrected copy, and it says here, shall be licensed to practice law in jurisdiction of the United States, complying with the law and rules of the That's what I thought. That's
My
not what.
apologies.
Yeah, because this one doesn't bother me as much. Okay.
I think this is the one here. Representative, is that the right one now, council?
Yeah, so it is, because it's on the message. So Sanders,
Would you,
why can't we just
Chairman,
say?
can you read that just to make sure all of us are
Mr. Chairman, some of the language and semantics, I understand as an attorney. I think the concern for the public is not understanding that you can be brought in from outside, from another state. So that's where we were trying to make that a little bit, not just clear for the statute books, but clear for the public too, who might be caught up in these circumstances.
Okay, let's go to Representative Vogel.
Thank you, Mr. Chair. So I was interested in hearing what the impetus was, what the rationale was. And I do appreciate it, but I'm against changing this language to basically opening it up to, this would open it up to any, more or less any licensed attorney in the US. And it just seems to create inconsistency in Wyoming law. So this is, the court martial is a state court. And currently in Wyoming, in state courts, you have to be licensed in Wyoming or there are other rules provided for in law and rules that you can do. And as Senator Ellis mentioned, like pro hoc vice, so those are the current, those things exist in law. That's the procedure that's followed. I understand not wanting to add the wording like of pro hoc vice into this because again, that's just, those are the processes that people can follow. But I don't see the reason that in this, as has been mentioned, largely JAG is used. They can hire outside counsel, and if it was from out of state, they can follow the pro hoc vice rules if they want to do that. Nothing precludes any person from doing what they do in every state court. So what this does, in my mind, is creates just an inconsistency in state courts and in state law. I haven't talked to the Wyoming State Bar. I think they might be opposed to it. Again, because it's different than if there's an outside attorney, then they're not the overseer. So that could create issues possibly. I haven't talked to them, but so bar licensing could be an issue with an out-of-state attorney. So it just seems to me that having a Wyoming lawyer authorized to practice and overseen by Wyoming Bar Council or by the Wyoming Bar, like it's done in every other state court, just makes the most sense. The reality is people can hire the attorneys they want, but they just need to follow the rules and the procedure that exists for every other state court. So I just don't like the inconsistency. People do have a choice of counsel. They can do that. Nothing prohibits that. They just have to follow the procedures that are in place. So I don't, this is a state court and I don't see any reason we would make it different than other state courts. That's my thought.
So
I'm sorry.
Just real quickly, Senator, I've got a question for the representative. So are there outside professionals, those who are represented in the Wyoming Bar? I mean, are there people living outside the borders of Wyoming who are members of the Wyoming Bar?
Mr. Chair, yes. So you can be licensed if you follow whatever requirements are by every state. Then you can, whether it's taking their test or whatever, but many people are licensed in multiple states. Technically, you could be licensed in all 50, you'd be paying a lot of bar dues, but you could, if you want to follow that. But so actually, yes, that's something that's very commonly done. Of course, you can imagine with Wyoming, with the way it is, a lot of our bigger cities being around the border. So Cheyenne and Laramie, there's people in Colorado that are Wyoming licensed that practice here all the time. And I think that's actually maybe a really good way to highlight why I don't think this is appropriate or necessary. That way, they have to opt in, follow the rules of the Wyoming Bar and submit to that process and authority. And without this, we've got people not licensed in Wyoming and not part of our bar practicing here, and it's not authorized in other places. So I just don't see why we would do that here.
So it feels like that maybe we might be okay with attorneys from elsewhere who are licensed to practice law in Wyoming, one of the interests, I think, on the Senate side was the fact that we have in the Wyoming National Guard lots of members who come from the Panhandle and from the state to the south of us. And so Senator Ellis, you had a comment. And then-
Thank you, Mr. Chairman. So just a couple of things. I mean, these are Wyoming courts technically, but I think the subject matter tends to be UCMJ. That was, if I'm not mistaken, a lot of the conversation that happened in committee. So I think it's not so much familiarity with Wyoming law per se as it is UCMJ in some of the unique circumstances like this. The reason this lady's case was so complicated was because of the dual nature of her and her serving in her civilian capacity and then in her military capacity. So, you know, I don't understand the resistance. Like I said, South Dakota does it pro hoc vice. I didn't understand Senator Perkins' concern with having the pro hoc vice language. You know, I've filed motions to practice or to appear before the Idaho U.S. District Court. This is something that we do. And, you know, I can very much see instances in a small state like ours where there might be conflicts and where they might want to bring in separate expertise. And so I think we just need to work on making that language clear. You know, maybe it is what Representative Greer has talked about, saying authorized through motion or something, but this is not going to upset the apple cart too much. This is what we lawyers do. We appear in other states for limited purposes.
So I propose, just, sorry.
Senator Pappas, and then we'll go to the chairman. I think we're coming close to maybe some language we can live with. Go ahead.
Thank you, Mr. Chairman. There's a sentence prior to what we want to change on 17. It says military defense counsel shall be appointed for any accused pursuant to the promulgated rules. So we're talking about a person that's going to be appointed. It's not, I'm going to hire my own defense counsel. I think you could do that, right? But this is an appointed counselor, right? It's appointed counsel, and I'm assuming the Wyoming Military Department will appoint that person. So I think that makes a bit of difference. If it's pursuant, I mean, if we're talking the accused is someone that's from Colorado or from Nebraska, or when I was the director of support at the highway, I had a guy who worked for me from Guam. I mean, you know, why can't you appoint someone from that region if you wanted to, if they were a licensed attorney? Because we're talking about military law, and granted, you know, we have our own code and it's Wyoming centric, but it's all based on the Uniform Code of Military Justice. And so I just don't see any problem with it. Frankly, I could probably live with what was there to begin with, but I don't see any problem with the new language either. I just don't see the issues that are being raised. Thank you.
Thank you, General or Senator. I mean, so Mr. Chairman,
Yeah.
I think you maybe have a thought for the committee.
I think, you know, there's good points, and the points are being made is that there may not be the expertise, there may not be maybe conflict, small communities, things we run into in Wyoming. Also, what Representative Oakley is saying is, you know, if you can practice in Wyoming, because it is a state court proceeding, you have to submit to the rules of our bar, and you have to be held accountable for it. So a possible solution, I think, that gets us there would be looking at the amendment is we'd come in with say council shall be authorized to practice in Wyoming and be a member in good standing of the bar of the highest court of any state in the United States, admitted to practice in any federal court of the United States, or hold a current position as a military judge advocate. And that gets the Pro Hoc BTA just by being authorized to practice in Wyoming.
And state that one more time, Mr. Chairman, just so the committee has.
You bet. After shall, just say shall be authorized to practice in Wyoming, and then be the rest of that stuff. And that's pretty good middle ground.
Okay.
I think clears that out.
You know, I think that gets us close as far as I'm concerned, but we did have, Mr. Winnie, go ahead. You've got some comments.
Yes, sir, Mr. Chairman. I may be able to provide some illumination Because what you're doing here is you are having a state court that is using the Uniform Code of Military Justice, Manual for Courts Martial, et cetera. Even though apparently they're referring to state active duty or so on. In the military system, a lawyer is appointed for the defendant. Now, he can go out and hire another lawyer if he chooses, but there will be an appointed lawyer from the JAG system in the military. The requirement for a guy to be a JAG in the military is he's got to be admitted to the bar somewhere in the United States, and then he's qualified in the military on the UCMJ. And this is a UCMJ trial, even if it is a state court. And there are quirks in the UCMJ that are different than state things. For instance, you don't ever see a hung jury in a military because when the court deliberates, 2/3 convicts, less than 2/3 is not guilty. So you don't get the hung jury thing. And so what you're dealing with is you're trying to parallel the UCMJ into a state court, but you're going to use the UCMJ. So what's more critical here is that he be knowledgeable in the UCMJ rather than Wyoming law. I would offer you, if a guy wants to then go hire his own attorney, perhaps that attorney should be a Wyoming attorney, but I would view that as less significant. So the issue of the guy being qualified in Wyoming, given that you're doing a UCMJ trial, Manual for Courts Martial, et cetera, doesn't make any difference. What's important is the UCMJ side of it. Subject to your questions, thank you.
Mr. Winnie, thank you. Any questions of Mr. Winnie? Okay, thank you, Bill. We appreciate it. Let's come back to, the suggested language. Senator Anderson, does that look like something you could live with?
Mr. Chairman, can we read it again?
We'll study it quickly. We got to get upstairs here pretty soon, but I want to make sure everybody can maybe get comfortable. Representative?
Thank you, Mr. Chair. There was a request to read it again. So if you could do that, and then, because I do like authorized to practice in Wyoming, because then that at least flags following the rules that exist. And that's where you're getting, and I like that. Because I do think one of the things, actually going to Mr. Winnie's testimony, talking about the importance of the knowledge of the lawyer is one thing. But what I'm concerned about is following something that the Wyoming State Bar and that the rules of our state require and are interested in. That's
Sure.
what I think the crux is here. So I'm certainly interested in an and, after you read it, there be authorized to practice in Wyoming, standing alone, and whatever. So if you'd read it again, Chairman Griggs.
You just said it.
Okay,
Can we read it again?
yes, please.
Read it again, will you? Council shall be authorized to practice in Wyoming and be a member in good standing. So yes.
I certainly feel like I can live with that compromise language. Representative Larson?
I'm following the lead.
Okay. Senator Pappas?
Yeah, what does it take to get authorized? Can you, as,
A motion. So if I want to practice, I don't have a license in Colorado, but I have a client where something comes up in Colorado. And I feel that I'm confident, in particular, there's a bankruptcy issue, I'm confident to handle that. What I do is I call somebody I know in Colorado and say, hey, I need to be admitted by motion. And basically what I do is I work out the motion, but that attorney they basically vouch for me. They file that motion on my behalf, that I can come down, and so just as accountability to the ethics and the responsibility to the client. Representative Oakley is 100% right on it.
so it's not difficult to
No.
get? Okay.
Okay.
To be honest, Senator, when they were talking about pro hoc vice, again, that's kind of what, that's what we're discussing. But there's got to be a way that when you're not authorized to practice in another state or another jurisdiction, that you're held accountable. I mean, I can't, I could just go file something in Montana and then never show up again. Well, they can't hold me accountable, even as the attorney. So there's just a lot of things about licensing and properly appearing in front of any jurisdiction or any court. And so Wyoming has an interest in that we have Wyoming lawyers and they expressed an interest in keeping it this way. But if we get there being that authorized, and that might mean a lot. I mean, it might mean steps as far as pro hoc vice and submitting yourself to our jurisdiction, but I think that's important.
Well, committee,
It's consumer protection.
yeah, I actually, I really appreciate the conversation. It's helped me to learn today, and I think I can support this. If you guys can support it, I'm good. Mr. Chairman, you good?
I'm fine. I don't want to interrupt your bill.
Well, it's an important bill. I will say that. And Senator Pappas and Senator Anderson worked this in the interim,
Yeah.
and
the
I
rest
mean,
of the bill is
it's
very
a bill
important.
that we all need. We know that. So by golly, if we're good, we'll work it all up,
Okay,
Mr. Chairman.
so I think if it's a house, we send that to the House staff, is that right?
I think
'Cause it's
so.
a House
I
bill?
think so, because
So-
you were asked to concur, right?
Yeah.
Yeah.
We were. So Representative Oakley, you get familiar with the process, you go, you take that in to Katie and she'll work up that and then we'll have to come around and get signatures from all of
Representative, you
us.
got that language okay
Yeah.
to take to your house folks? And yeah, so that we'll just work that around and get some
You
signatures.
can't read my handle.
That's right. I bet I can. It's my pleasure.
Okay.
Well, thank you very much. I think we're done.
Legal counsel.